G'day, welcome to Silverstone Technology Cluster's Ask the Expert podcast. Today's episode is proudly brought to you by TC Group. I am Jeannie, your host, and I'm absolutely thrilled today to have Dominic Hopkins and Ruth Sheret with us. Dominic and Ruth are joining us from HCR Hewitsons. Thank you both for being here.
Pleasure. Great to see you.
So can we start by getting to know the two of you a little bit better? Can you tell everyone about your backgrounds and what led you to your current roles?
Yes, I'm a partner in HCR Hewitsons. We're based in the Central England office. I'm a joint head of the Central England office. My field of practice is in dispute resolution, which is quite a broad topic, broad area, covers a diversity of different types of issues facing clients. And I will commonly be acting for large and small organisations, SMEs, through to large international groups involved in complex issues that are affecting their business. And I help resolve those, often where there's a breakdown in a relationship between trading partners and the like. Ruth.
Hello, Jeannie. I have a broad practice at HCR. I've been with the company about 6 years now, and I'm a general regulatory lawyer. That means I deal with regulatory criminal law for clients who are facing enforcement or prosecutions or other actions by regulators such as the OPSS or the Health and Safety Executive or fitness to practice committees, all sorts of different people. My background is actually in defendant personal injury work. So I've done a lot of claims, a lot of prosecutions, and a lot of inquests into deaths and serious injuries in the past. And I've done a lot of product safety and product liability work, focusing on products in, well, at one point for a global manufacturer of fast-moving consumer goods. So that was a worldwide project. At HCR, I represent all sorts of manufacturers, suppliers, retailers in the product safety sphere.
And I think it should be worth adding that Ruth and I, with our experience, do support our technology sector practice, our technology sector team. So we're part of that wider firmament of technology that the firm works with.
So you're both coming at it from quite different angles. So let's dive into the discussion today. Dominic, we're here to talk about buying and selling across borders. So from a legal perspective, let's start with 3 key things a UK business needs to think about when they're selling across borders.
Well, first up, I'd say a key issue: evaluate the business and legal risks in the markets concerned. When you're selling overseas, it's well worth consulting with a local expert on the legal and regulatory framework governing the supply and use of the product concerned. And that's not just the conditions for exportation. Also, ensure you've worked out how you're going to get paid. That's critical. But don't assume that the law and the protections are the same everywhere you trade. They're not. For example, it's worth working out how to protect your intellectual property in relevant jurisdictions and ensure that the trading of your product doesn't infringe on others' IP rights there. Again, I think I'd recommend specialist local legal assistance for that exercise too. Fundamentally, getting an appropriate contract in place, choosing the right law for your contracts and considering how you might need to enforce your rights under those contracts. Because law is not unified across state borders, and choosing the right country's law for your contracts can be commercially important. So think through how things may play out if a problem arises.
Okay, so following on from that, whose law is actually best to trade with?
That's a really good question, actually, and often comes up. It depends on the particular circumstances of your trading. It might depend on whether you are a supplier or a purchaser. It might also depend on the jurisdictions involved in the trade.
Okay.
But there are laws that are globally well respected for mercantile purposes, and English law is preeminent among those. English law is trade-centric. It has a long history of development and brings certainty, which is often what people are looking for. So a good example would be a major shipbuilding dispute that I handled between a large Emirates undertaking and a Chinese shipyard. The parties chose English law to govern the contracts, even though neither of the parties had a place of business in England or the UK. The arbitration took place in the UK, but it could have been somewhere else. English law was chosen.
So, Ruth, a couple of questions for you. I know that this is kind of very relevant to a lot of us. Now that we've left Europe, presumably our laws are different to those in Europe?
Yes, Jeannie. Whilst a lot of my area, product safety, before Brexit was very, very similar to EU law, if not exactly the same in some circumstances. And immediately after Brexit, there were pretty minimal substantive differences. The further along in time we've gone, the more and more changes we're seeing. So I think really that began with the EU market surveillance regulation in 2019, 2020, which came into force for EU member states. That required them to have an economic operator present within the state if they were based outside the EU for certain products. Now, that's expanded again late last year in December 24 with the new General Product Safety Regulations, which now requires anybody that puts a product on the market in the EU, whatever type of product it is, to have an economic operator present in the EU. Well, that's a cost for the company in having to have somebody present in the EU that they didn't have to face before. And you need to know about EU law to trade in the EU. And the more time progresses, the more the changes are becoming apparent. So looking ahead, we've got the Product Liability Directive coming into force in the EU. By the end of 2026, all EU member states must have brought that directive onto their statute books. That's going to contain some fairly serious changes that are going to affect consumer claims brought against manufacturers. That's going to make it much, much easier for consumer claims. That kind of point is not present in the UK law at the moment. Equally, in the UK, we've got a new product manufacturing, product safety and metrology bill coming in. That's going to be in force in the near future. That's going to contain some changes that are dissimilar to what we're seeing in the EU. So I think there's going to be increased divergence between the UK and the EU product safety frameworks moving forward. And there's just no guarantee that our future changes are going to mirror those in the EU.
Okay, and from a practical perspective, what does that mean for manufacturers and distributors in the UK?
Well, unfortunately, I'm afraid it means that if you are selling into both markets, you've just got to keep up to date with the laws and the changes in those laws in both markets. There's just no getting away from it. And of course, this all impacts on the contracts in the supply chain. It's increasingly important to negotiate when you're making the contract, the right warranties and indemnities, and try as far as it's possible to look into the future and future-proof your contracts. Anticipate what changes are coming in the future and try and think, how can I make sure that if it does all go wrong, I've got the best possible scenario.
Okay, and you touched a little bit earlier on safety and regulations. We do hear about products being recalled, but at what point does a business need to consider recalling a product?
Well, product recalls tend to strike terror into the heart of manufacturers because it is the kind of worst case scenario. So let me explain what we're talking about in product recalls. So we're not talking about just a consumer complaint that the product doesn't quite work as it's supposed to. And we're not talking about just a a slightly wider quality issue where perhaps a manufacturer isn't really satisfied with the product, it's getting too many customer complaints, and it's just thinking, well, maybe I should do something about the quality of this product. We're talking about situations where perhaps a consumer is complaining that the product has, worst case scenario, blown up and burnt down their house. The consumer is alleging that they've sustained personal injury, they've got lots of property damage, or even a situation where a consumer or a regulator is saying this product could catch fire and burn down a house. It could present a safety risk. So when you've got that situation of a safety risk, that's when you need to start thinking about product recalls. So let's go back to the worst case scenario. Consumer rings up and says, your product has exploded, blown up, burnt down my house. It's cost me a fortune to put right. I want you to pay for it all. Now, if you're the manufacturer, you need to take the allegation seriously, even if you're so confident in your products that you're pretty skeptical about the consumer's claims. You need to take it seriously because there are criminal offences connected with product safety, and even the point of not taking it seriously when somebody complains, that can be a criminal offence in itself. Equally, don't panic, is my advice. So take some details from the customer, and at that point, consider whether you need to be making a claim on your insurance policy. Then consult your product safety incident plan. All manufacturers should have one of these. In my experience, they don't necessarily all have a product safety incident plan, but let's say they do. So that will require you to identify the exact nature of the safety issue, and then you have to investigate it very carefully. So you might need to set up a multidisciplinary team consisting of experts in product design, for example. You need to identify all the relevant information to enable that team to come to a reasonable assessment of what exactly is the safety issue. So they'll be considering things like design flaws, batch testing, consequences of product safety failures, that kind of thing. You need to do a risk assessment to assess the risk of this happening again. And at that point, you may need another multidisciplinary team that is able to assess risk properly. There are some guidances out there in the UK. We have the British standard PAS 7100 2022. That's a recognised standard that sets out a methodology to assess risk. In my experience, companies tend to find it quite difficult to follow. You have to sort of pay quite close attention to it. But it is possible to follow it, and pretty much following that is good evidence of compliance. So once you've done your risk assessment, then the company needs to decide what corrective action it needs to take. A product recall is the last resort, really. Hopefully, once you've done your risk assessment, even if the customer has complained that your product has blown up and burned down his house, you might decide it's actually a customer handling issue, and therefore you don't actually need to do anything. You just need to handle that customer separately. So the range of options for corrective actions range from do nothing, change your labeling, change your instructions, maybe issue some warnings, and last resort, product recalls. You'll also need to, sorry, I've got one more thing to say, Jamie. You also need to notify your local authorities. So in the UK, you would notify the trading standards. In the EU, you notify the Safety Business Gateway. For general products, obviously food, pharmaceuticals and automotive products have their own regulators.
Okay, and is there a common mistake you see with companies that are going through this process and that are facing this challenge?
Yeah, in my experience, communications is a key area for making errors that can really come back to bite a company. So companies tend to say too much too soon, and they might invalidate their insurance policy by doing that. Or they might be too vague, too unclear in their communications with customers when they're trying to do their corrective actions, and that kind of undermines their corrective actions. And also, be very careful when you're writing stuff about a product safety incident, because anything you write down within the company is potentially evidence in future litigation. Of course, all claimants are looking for that ultimate smoking gun, the hidden document that proves you knew it was going to happen, that kind of thing.
So back to you, Dominic. If a business is worried that a buyer of its products or a supply partner might be taking advantage of information they've been given about such products or processes or the supply chain, are there ways of managing these risks?
Yes. If you are an innovator and trade secrets are integral to the design and build of your product, but to achieve your trading purposes, you need to talk about these things with counterparties in the development of a supply chain. You're naturally going to be nervous about disclosing confidential information. It's understandable. It's a real risk. It's a risk, though, that you just might feel you need to take just to get on. And as to that risk, information flows like water through all sorts of gaps. I like to characterize information as water because it's a kind of visual representation of actually how it works. Once released, it's really hard to control. However, there are measures you can take to mitigate the risk, and one of those is a well-drafted non-disclosure agreement. I say well-drafted because the agreement needs to be clear as to what information is being protected and what the obligations of the person who's receiving that information are. And you also need to consider how it might have to be enforced. And that might be cross-border, which brings into play all the points I made at the beginning of this podcast, which around different laws of different jurisdictions.
Okay, and on that, what if the information does get out and someone discovers that their confidential information has found its way into the hands of a competitor? Is there anything that can be done about that?
Yes, I'd start with going to see a specialist lawyer, somebody who can help you review what your options are, taking into account the fact that it can be highly technical. The issues arising from the breach of confidentiality and essentially ownership of information are highly technical. A careful examination of the evidence will be key for the lawyer and the client. And technology can, of course, play a major part in finding a solution. But that technology itself, electronic communications, have almost made that water even more runny, if I might put it in those terms. It's given more zest to the flow of information. So moving quickly can be really critical to stop what might be quite damaging if it gets dissipated even further than it already has.
Okay, so at the start you talked to us about your work with dispute resolution, and I know in most cases trading does go smoothly, there are no issues, there's no disputes. But if one occurs, or it looks like there may be one coming up, where do you start with that?
Where do you start? Well, I'd start actually at a beginning, and the beginning will be fundamentally the contract that you have, your supply contract. Most commercial terms, most commercial contracts relegate terms dealing with disputes right to the back end, which is an understandably human response. I mean, why would you want to dwell on what happens when things go wrong and put that prospect right up front in your agreement? The focus is rightly going to be on a relationship building exercise, a positive exercise, rather than one looking at how it's all going to fall apart at some point in the future. That said, a well-drafted supply chain contract is going to set out expectations for what should happen if things do go wrong. With technical products, these provisions can be pretty complex. They might involve provisional measures for market protection. Product recall is a subject which Ruth has already spoken about. And evaluation and escalation processes may well be an ingredient of the procedures, with opportunities possibly for technical discussions first, and then a senior management board, a disputes board possibly for the parties, and also the prospect of a negotiation process, such as mediation. Ultimately, the parties may, however, have to consider litigation, which is a court process in whatever jurisdiction you are operating, or commonly in international supply chains, you'll be looking at an arbitration clause. Complications can, however, arise in supply chains if the dispute resolution provisions are not aligned upstream and downstream. Think about the way in which you might have a dispute that impacts from the top of the stream all the way down to the ultimate customer, the place in which the product is actually being used. Each of those chains, each of those links in the chain might require a dispute resolution process to be applied. And if you've got a variety of those processes up and down the chain, that can make it quite complex. So that's something for people to think about when they are in a supply chain.
You know, what are the main options for resolving disputes that are available?
Well, there can be a confusion between the various options that are available, and there are quite a number. The confusion can exist between what are essentially adjudication processes, those that decide a matter on the evidence and law. That, for example, might be litigation, the courts, or arbitration, where an arbitral panel makes a decision on, as I say, the evidence and law, on the technical aspects of the matter, as well as the legal principles. And the distinction that needs to be made with negotiation processes, such as mediation. Mediation is not a place for adjudication. It's a place where no decision is made as such by a mediator, but the parties are helped to find a route to settling their dispute. Ultimately, the contract will, well, say commonly decide, it should decide which is the default process. And in international supply chains, arbitration will generally offer more international enforcement options and is therefore not uncommonly the procedure of choice. The issue, of course, that commonly comes up is cost. Both litigation and arbitration are costly. They can be blunt tools. Each has its advantages and disadvantages, which need to be weighed up. So it may well be worth looking at one of the other options to solve the problem. Well, HCR's dispute lawyers are, of course, well versed in helping clients make the right choice for the case, and very happy to help anyone inquiring on that front. The options, interesting, are also increasing with new ideas entering the market. There's one called Pink DR, it's pink with a Q, and that's an example of a low-cost online arbitration procedure for an adjudication in a short time frame. Again, that might look attractive, it might be right for a simple dispute, but it might not be for another. So it's about horses for courses, choosing the right process for the matter.
Okay, that's really interesting and really helpful. Thank you. I just want to thank you, Dominic, and you, Ruth, for your time today. It's been a really enlightening conversation and really interesting, and I appreciate you coming on.
Thank you.
Great pleasure.
And to all of our listeners and our viewers, thank you for tuning in, and be sure to subscribe to STC's podcast and stay tuned for future episodes.